welcome very much.
Thank you so much, Clark, and thanks so much to the Aspen Security Forum for making space in this conference to talk about these really critically important issues framed through a legal frame. I'm going to introduce the panelists to you now with the precatory warning that I could read all of their biographies and we could spend the entire hour and a half doing it. Each of them is worth that kind of introduction, so I really urge you to look at their full bios in your materials, and I will introduce them as briefly as I can with the understanding that I'm sorry that I'm not doing full justice to any of them. Seated directly to my right, Alberto Gonzales, sworn in as the nation's 80th Attorney General in February of 2005. Prior to serving at the Justice Department, he served as White House counsel to President George W. Bush. And prior to service in the White House, he served as a justice on the Supreme Court of Texas. Welcome, Judge Gonzales. Then we have Anthony D. Romero, the executive director of the American Civil Liberties Union, the nation's premier defender of liberty and individual freedom. Romero took the helm of this organization only 4 days before September 11th, 2001. The ACLU, shortly after that, launched its National Safe and Free campaign to protect freedoms during a time of crisis. And Anthony has worked on issues including the torture and abuse of detainees in U.S. custody and filing the first challenge to the Bush administration's NSA spying program. So, Anthony, it's pleasure to have you and to welcome you. Seated next to him is Bill Bratton, chairman of Kroll, the world's leading risk consulting company. Mr. Bratton joined Altegrity in November 2009 after serving as chief of the Los Angeles Police Department for 7 years. Chief Bratton is known as one of America's premier police chiefs, the only person to have led the two largest police forces in the United States. That's the New York City Police Department and the LAPD. He is vice chair of the Homeland Security Advisory Council, and last year was named by Security Magazine as one of 2010's most influential people in the security industry. Welcome, Chief Bratton. Seated directly next to him is Professor John Yoo, a professor of law at the University of California at Berkeley. Professor Yoo's new book is Crisis and Command, A History of Executive Power from George Washington to George W. Bush. Professor Yoo has published more than 75 scholarly articles on foreign affairs, national security, and constitutional law. He was Deputy Assistant Attorney General in the Office of Legal Counsel in the U.S. Justice Department, where he worked on national security and terrorism issues after the September 11th attacks. And finally, welcome, John Yoo. Finally, to his right, David Cole, who teaches constitutional law, national security, and criminal justice law at Georgetown University. He's also a volunteer attorney for the Center for Constitutional Rights, a legal affairs correspondent for The Nation, and a contributor to the New York Review of Books and NPR. He's been published widely on various issues having to do with law and national security, and his most recent book, Less Safe, Less Free, Why America is Losing the War on Terror, was published in 2007. And he has also, I should add, litigated many of these cases before the U.S. Supreme Court. So I'm going to start with a very, very broad question for the panelists, possibly absurdly broad, because there's nothing like talking about law early on a Saturday morning. And I thought I would ask a simple question about lessons learned. We are coming up on the 10th anniversary of 9/11. And I just want to ask you to each give us 2 or 3 minutes, if you would, on what we've learned about the relationship between the rule of law, civil liberties, national security, the global war on terror since 9/11. I wonder if we're safer today than we were 10 years ago, if we're more free or less free than we were 10 years ago. Does freedom matter in a global war on terror? I wondered if you could think a little bit about whether the war or crime paradigm is the one that we should be using moving forward. In other words, what have we done right? What can we do better? What is the signal lesson, in your view, of the last 10 years on these legal issues? And I'd like to start with you, Judge Gonzales. I know that's a question that could take up 16 years, but if you can just give us a cursory initial thoughts, we'll take it from there.
Well, one thing that I would say is
the rule of law is important. Constraints on the most powerful nation in the world is important. It's important to our allies. Quite frankly, it's important to the critics of a president. They want to know how is your power constrained? And when I would travel overseas as Attorney General and we would debate these issues with my counterparts, that's the question that I would always be asked. Okay, what rules bind the United States? I believe it's important for the most powerful person in the world, the President of the United States, to be constrained by some rules. And as lawyers, what we endeavor to do is to provide to the President the box in which he could operate in. As a policymaker, he would decide how close to the edge of that box he would get. But what he expected of the lawyers, working with John Yoo in the Department of Justice when I worked in the White House, was to define that box for the President. And so certainly for me, it was important, and I think it was important for President Bush in terms of the constraints that exist on the most powerful nation in the world and on the most powerful person in the world. And the second point I would make is in terms of the paradigm. I operated from the perspective that I thought it important for the President to have as many options as possible in dealing with this new kind of threat. And therefore, I thought it important to have the criminal justice system available to deal with people that we captured. I thought it was important to have the military justice system available as well. Now, there were some in the administration who believed that anyone engaged in terrorism should be dealt with through military commissions or detained indefinitely. I wasn't of that mindset. I believe that under appropriate circumstances, our criminal justice system was available and was appropriate to bring people to justice. And so, for me, as the counsel of the President and then as the Attorney General, I thought it was important to give the Commander-in-Chief, the President of the United States, as many options as possible to deal with this new kind of threat.
Thank you. Anthony Romero?
Well, first, Dahlia, thank you to the Aspen Institute for inviting me to be part of this discussion. And I'm especially pleased that we have a police commissioner in between our respective sides here, because if we get into a scuffle, I think he's been and the taser gun, because that might be the only way you can actually restrain me this morning. But let me. I'm sorry, I've had a lot of coffee and my Puerto Rican heritage comes out. Let's start with the basic. We talked yesterday about the importance of securing the homeland. And there's perhaps no greater threat to securing the homeland than America's willing abdication of her moral authority at home and abroad. And the utter lawlessness of the Bush years, beginning with the surveillance of American citizens without congressional approval or the review of the judiciary, the detention of American citizens without charges or trial apprehended on American soil as enemy combatants, the establishment of black sites where torture was committed, not enhanced interrogation techniques, not these lovely little euphemisms for that which is unconstitutional, illegal, and war crimes, and the absence of ensuring accountability for crimes committed by Americans and authorized at the highest level of our government. And that breakdown of the rule of law is equivalent to the meltdown of the financial system. The complete legal system collapsed on its head. Boxes were broken. Rules were changed. People were unfettered to pursue what I understand to be a good cause, to keep America safe, but then forfeited our ability to be free. And if you look at the discussion we had yesterday about the importance of securing American leadership on the Arab Spring and the importance of promoting democracy, frankly, the hypocrisy is quite remarkable when you think about the fact that America, once the progenitor of these great values, lacks the moral standing abroad and at home to do that which we need to do to secure the homeland. And I'll just close my polite opening by saying that there's probably no greater set of conversations that need to be had. That this is a set of issues that too often has been done behind closed doors among reified parts of the American government with very little input or knowledge of the American people. And perhaps the most important thing that we can do is to break open this conversation, to have forums like this one where we thrash out the issues openly, where we know the facts, where we have a conscious and very important conversation with the American people about the country we want to live in. And frankly, it's not about the enemy combatants or the fellows in the orange jumpsuit, and it's not about the Al-Qaeda, and it's not about the Taliban. It's about who we are as Americans. What are those values that make us proud to be Americans? And that's the kernel of that debate, which often has gotten lost in the scuffle over the last several years. Now, lest you believe that I'm only parking responsibility at the former Bush administration, I think the Obama administration also deserves to be called on the carpet for its unwillingness to take on these issues with the seriousness which they deserve. We needed a very similar aggressive plan as we had with dealing with the financial crisis to dealing with the rule of law crisis. And frankly, this president's come too short, too little, often too late, too timidly to deal with the issues. And perhaps no more important to me is his unwillingness to look back and to deal with the torture, to deal with the crimes, and to prosecute those who were responsible for that, even at the highest levels of our government. That effort of putting one's head in the sand and the effort to push forward will only mire us in the past, as I think the recent debates about whether or not enhanced interrogation techniques are still valuable or not. We would not have that debate if we had called it for what it was and done what law enforcement officials should have done, which would have been to prosecute those who were responsible for it.
Thank you for the very mild opening.
It's
it's
in my nature.
I know. Chief Bratton?
Okay. Where do I begin? What has changed for American policing? I'll speak from the American policing perspective because that's the world I've operated in for 40 years. Relative to the rule of law, pre-9/11, post-9/11, being quite frank with you, nothing. The rule of law before and the rule of law for American policing is still pretty basic. You don't break the law to enforce the law. You police constitutionally within the law. You police compassionately. You're policing human beings, and you deal with them as such. And you police consistently, whether in a minority neighborhood, poor neighborhood, rich neighborhood. Those are the guidelines. And as it relates to the use of police powers, there's some pretty bright lines that you don't cross that, fortunately, over the last 40 years or so, have really been enhanced significantly by rulings of the courts as it relates to police. Going back to when I first came into the business in 1970, following a period that was not a celebratory period in American police history, where use of third degree was very commonplace. Segregation was still the law of the land, or had only recently been changed in large parts of this country, where police had enforced those laws. That we have benefited by the constitutional interpretations of the Supreme Court that brought Miranda, the exclusionary rules, many of the bright lines that we do not cross, dare not cross, as a profession. Not to say that individuals in our profession basically take that risk sometimes for improper motivations, sometimes they might argue for pure motivations, but in any event, when they do cross them, we have gotten much better at dealing with those transgressions. So that this issue of terrorism, pre-9/11, local police, with a rare exception, had almost no involvement in the issue. And that involvement was usually through federal task forces, the joint terrorism task forces in major cities. Post 9/11, we've had a lot of catching up to do, a lot of arguing that we have a place at the table to deal with terrorism, arguing that police, local police, hometown security is as important to the national security as international homeland security. And that the role of police, however, has not changed as it relates to dealing with individuals in terms of how we treat them, and that we do not and cannot and will never condone the use of torture or excessive force. We've come a long way in American policing in the last 40 years, and under the tremendous pressures of dealing with the issue of terrorism, I'd like to think that we have not fallen back in American policing. I think the challenge for federal agencies has certainly been different, because as it relates to terrorism, if we come across terrorism, the way it works is we immediately move it into the federal domain. We support it, we assist them, but we are not the driving force. So our challenge has been less complex, I think, than that of our federal colleagues in the federal agencies, the alphabet agencies, if you will.
Thank you. We now turn to the professors. Professor Yu?
Well, thank you to the Aspen Institute and to Clark for including me in this panel. It's always a great chance to leave the People's Republic of Berkeley and to come to more conservative towns like Aspen, Colorado. Also, I've been here for the whole conference, and I'm still waiting for someone to tell me how Clark received the award for the best named person in the world. Because I always thought Clark Kent Irvin is such a great name. I always thought my family had him beat by choosing to come to a country where my last name is the most used pronoun in the language. But I'm still waiting for the explanation how he got this great name. And I've also really appreciate the opportunity to come here and to be on this great panel. Me Versus Everybody sounds like a great book, but sounds like my everyday life at Berkeley. So I feel like I really haven't left home. I just want to make three very brief points about, and most of I'm afraid I'm going to be reacting to Mr. Romero, who's Puerto Rican blood. Don't get a Korean mother started on who's more hot-headed, because we can outdo you. Don't I guarantee you. But one, I don't think the biggest threat to American security is the claim that there's some kind of lawlessness or broad unconstitutionality going on here. I think what troubles Americans, I think quite rightly, and I think the ACLU, and I'm very happy that they exist and they do what they do. We need to have watchdogs like them in existence. Is they have blurred the rules of war and made it seem like the rules of war are seeping into the domestic system, that a separate body of ways to act against an enemy are being portrayed as if they were going to be transplanted into the American political system, American domestic system, and uprooted everything we do. Chief Bratton just said now that in terms of policing, the rules are pretty much the same, and I very much agree with him. I don't think that there's been any kind of huge disorder or disruption or pulling back on civil liberties for Americans in the United States. I think if you look all around yourselves, the last 10 years, maybe the bin Laden killing we're going to look at as the bookend of a 10-year war on terror period. I don't think so, but maybe that'll be the case. Ask yourselves, have civil liberties really declined in any significant way in the country? I would actually say the opposite. I've been amazed in the last 10 years at the great outpouring of freedom and liberty, not the government's fault or to its credit, one way or the other. I think because of other things like the internet, because of changes in technology, changes in the economy, we've got a great outpouring of freedom and civil liberties in the country. The second thing I would say is that I think that because of people's unfamiliarity with the rules of war rather than normal police rules, I think most Americans are very familiar with the normal police system because, not because of the great work of the police chief. And I do want to say, if I had been asked 20 years ago that I would have such a nice meeting with a police chief, I would have been amazed, because I was always worried about meeting a police chief. That everybody in America is familiar with Miranda. Everyone in America is familiar with their rights to a lawyer and everything because they all watch Law and Order, right? Because it's on TV every hour of the day on some channel, right? That's the system people are familiar with. So when they see the rules of war, when they see that you can have detention without trial in wartime, they think it's alien or it's some kind of violation of civil liberties, but it's not. There are a standard set of rules in war that are just different. And so let me focus on just one particular issue I think that Mr. Romero didn't raise, actually, which is targeted killings. Because one thing that's really impressed me throughout this conference has been how critical everyone from both administrations think targeted killing has been to the successes of the Obama administration. It seems to me if you were really worried about civil liberties, you would be jumping up and down, yelling and screaming about targeted drone killings just as much as, if not more, than what I do prefer to call aggressive or coercive interrogation and not torture. Because in drone killings, we are going out, sending drones, and we are not just putting pressure on people to give us the information about where Osama bin Laden is. We are killing them. We are depriving them of their fundamental human right, which is to be alive. And we're not just doing that. We are also happen to be killing people who stand around them, who may be completely innocent, who are in the target zone of these weapons we're using. I don't see the civil liberties crowd, I don't see the media and everyone jumping up and down claiming that we're engaging in massive human rights deprivations through targeted killing program, even though this administration has quintupled the use of drone killings, has killed way more people using drones than anybody was ever waterboarded by the Bush administration. I think the figure that the CIA guys gave yesterday was 3 people. So I think there's been a lot of inconsistency in the use of the phrase civil liberties, a lot of claims about whether they are in good shape or not. One last point, and then I'll stop, is, but suppose they're right. Suppose everything that David's, well, I'm not going to say that. I'm not going to say suppose everything David is about to say is right. But suppose everything Tony says is right. So now we've had the end of a 10-year period in wartime. Maybe the war on terrorism is over. I don't think it is, but maybe it is over. It's worth asking yourselves, compared to any previous American war, have we had a war with less deprivation of civil liberties? You look at the World War II experience, look at the Civil War experience, and what happened to people who protested the war. Abraham Lincoln engaged in massive detention of not enemy combatants, of American citizens, as did FDR. Hasn't any kind of infringement of civil liberties in this war, if they did occur, haven't they been much less? And so wasn't it worth it? Because I think that's the last thing to ask yourself. Everything about security and war and even law involves trade-offs. And so the last thing to ask yourselves, was the trade-off worth it, even if what they say is true?
I guess everything you're about to say, Professor Cole, is about to be said. Go ahead.
Well, I think I basically agree with everything that's been said so far. So,
Could you sign the stop?
I especially want to join John and the rest of my panelists in thanking Clark and thanking the Aspen Institute for having us here. It's an amazing place. It's an amazing group. And it's kind of unusual for many of us who are on this panel to be part of a conference, a 3-day conference in which law is almost never discussed. So it's kind of interesting from our perspective. I often serve as a kind of lone voice in the Federalist Society conventions, and John will serve as a lone voice in the American Constitution Society conventions, representing the point of view that's not reflected otherwise. And here we're all doing that by talking about law for one session during a 3-day conference on security. So I'm grateful to be here. What I want to say is that I think what we've learned in the last 10 years is that the rule of law is actually much more resilient than I think many cynics thought, and many people would have predicted on 9/11, and that I think many Bush administration officials, including Judge Gonzales and John Yoo, thought on 9/11. I think on 9/11, had you said to somebody, the United States is not going to get away with doing whatever it wants to respond to this attack, you would have been laughed at. You would have said, who's going to stop us? We're the most powerful country in the world. We've just been attacked in one of the most horrific, brutal, inhumane attacks known to mankind. They have no friends. We have lots of friends. Who's going to stop us? And I think that is actually the mindset that unfortunately operated. I don't see much of a box that John Yoo or Alberto Gonzales created for the president, unless the box has infinite lines. Because Alberto Gonzales said the Geneva Conventions are quaint, obsolete, irrelevant, don't apply. John Yoo said law doesn't apply when the president is acting as commander-in-chief. As commander-in-chief, he can ignore the fact that Congress has made it a crime to commit torture. He can ignore the fact that Congress has made it a crime to wiretap people without judicial approval. Because he's commander-in-chief, he's essentially above the law. Where's the box? If international law doesn't bind, if constitutional law doesn't bind, if the president is able to do whatever he wants, and then you get a president who decides that we can send people to third countries to have them tortured, we can torture them ourselves using waterboarding and the like, we can disappear suspects into CIA secret prisons for years at a time, keeping everyone out. We can create military commissions that can execute people on the basis of coerced evidence without judicial review. We can create a prison which is designed to be beyond the law and which is argued by the Bush administration as being beyond any judicial review. And then we can torture people there. That was the response. But what I think the important lesson is that on each one of those measures, the Bush administration was forced to retreat. On each one, it was forced to retreat. Once these policies became public, often because the media disclosed them, and only because the media disclosed them, the Bush administration was forced to retreat, and the rule of law reasserted itself. And so the second part of the Bush administration was much more, I think, consistent with the rule of law than the first part of the Bush administration. And the Obama administration came in and further asserted the force of the rule of law, banning torture, closing the CIA black sites into which we disappeared suspects, releasing the torture memos, insisting that the fight against al-Qaeda must be fought within the rule of law, not in spite of the rule of law. And what do we know? What have we learned from that? I think two things. One, these lawless actions were not necessary. We have been just as safe, if not safer, under Bush 2 than we were under Bush 1, and under Obama than we were under Bush 1. Two, they were not necessary because most of these measures did not, in fact, identify any actual terrorists. Rounded up several thousand people here in the United States on terrorist preventive detention measures, none of whom stood convicted of a terrorist offense 3 or 4 years later. So they were unnecessary. And the second thing we've learned, I think, is that they were tremendously costly. Why haven't we brought anybody responsible for 9/11 to justice? Because of the way we treated the people who were responsible for 9/11 by torturing them has created incredible roadblocks to bringing them to justice. We should be bringing them to justice, but short-sighted decisions to short-circuit the rule of law have led to very long-term costs in terms of bringing justice. They've also, of course, led to long-term costs in terms of al-Qaeda recruitment. You look at their recruitment literature, and Guantanamo and Abu Ghraib are right there, front and center. The best recruitment they could ever have hoped for, and we gave it to them. And then, of course, it's undermined our relations with our allies. I was living in Britain a couple of years ago, and they took a poll on who's the most dangerous person in the world, and Osama bin Laden was number 1, but George W. Bush was number 2. And when that's the view of our closest ally in the world, that's not good for American security. So I think we've learned that the rule of law can reassert itself through the efforts of organizations like the ACLU, through the media, through people insisting on the importance of principled responses. And I think we've also learned that these shortcuts that people like John and Alberto Gonzales authorized were unnecessary and I think very harmful to America's standing in the world.
I want to follow up on one issue that several of you have pointed up today, and that is whether we as a country have moved back, sort of retreated from some of what David Cole describes as the overreach, or if in fact we continue to overreach. And I think there's some dispute between each of your opening statements, David Cole and Anthony Romero, on that question. And I want to ask it in the context of civilian trials for terror suspects. It seems to me, and Judge Gonzales, maybe I'll direct this at you, that it was an uncontroversial or relatively uncontroversial proposition at the beginning of the post-9/11 era that terrorists would get civilian trials, or at least some terrorists would get civilian trials, and now that seems to be off the table in this country. And so I guess I'm just wondering if the discourse has massively changed. If you didn't know that there hadn't been another 9/11, you'd think there would had been many, many of them subsequent to 9/11, that the trial system wasn't working and that we had to overcorrect for that. So I wonder if how it's possible that things that seem to be not just possible but a good idea, like civilian trials, have now been really wiped off the table for terrorists.
I'm not sure I would agree that it's been wiped off the table. I think it's for many Americans, it's a bad idea for certain terrorists, depending on the circumstances. Now, I will say that within the Bush administration, when I worked in the White House, I mean, again, as I said in my opening statements, I always believe that criminal trials should be an option available to the president. I also believe that there would be certain circumstances where that would not be a good idea, and that we should continue. We should continue to hold them, detain them indefinitely, which we are allowed to do under international law. If you're an enemy combatant, there's nothing unlawful about that. Or we bring them to justice in a military commission. So I think the reactions that we're seeing about concerns about criminal trials in New York City, I think it's based upon the specific circumstances. But I think it's wrong to say that criminal trials for all terrorists are off the table. We know the department is capable of prosecuting terrorists in our criminal justice system, and under the appropriate circumstances, we should continue to do so. Now, let me just respond to Professor Cole about operating outside the rule of law. And I can't tell you the number of hours the lawyers spent in my office, at the Department of Justice, at Defense, at State, CIA, working through these issues. Because the President made it very clear to me that we were going to operate under the rule of law. And it was our job to frame that box for the President of the United States. Because if we operate outside that box, there would be consequences, and people should be prosecuted if operating outside that box. And so the notion that we sought to create an environment where this administration could operate outside the rule of law is just wrong. We worked extremely hard, the lawyers did, to make sure that we did operate within the rule of law. Now, were mistakes made? In all conflicts, mistakes made. Abuses occur. That is, you have abuses that occur in Aspen, Colorado by the police department. People make mistakes in law enforcement. People make mistakes when you're operating in the military. And when those mistakes are made, there should be accountability and people should be brought to justice. But again, the notion that we tried to operate outside the rule of law is just wrong. We worked very, very hard. And by the way, we spent a great deal of time talking to the Congress, both with respect to the President's surveillance program, also with respect to enhanced interrogation techniques, to make sure that they understood that this is what we were doing. And I would say almost universally, there wasn't opposition. In fact, there was either acquiescence or there was encouragement to do more because for this administration, for this country to succeed in the war on terror, we have to have information. It's very, very important. And I remember in 2002 when George Tenet came to the White House saying that we needed to find a way to get more information from these terrorists. And so the Department of Justice was asked to provide legal guidance. But even after the department provided legal guidance, Tenet, McLaughlin, and others at the agency were still very, very worried about going forward because they worried about the repercussions. They worried about the criticism from the media and from groups like Anthony's. And they were afraid of going forward, that the administration would abandon them. And what you're seeing today is exactly what they feared. That even though they have the guidance, they're worried about going forward and gathering the intelligence that the lawyers are saying is they're entitled to get under the law. And so that has been a serious problem, in my judgment, with respect to the collection of intelligence in this country.
Anthony, I wonder if I can ask you a follow-up. You certainly flicked at the idea that a lot has changed since the Bush era, but a lot hasn't. Yes. And I think some folks have even said that the Obama war on terror policies, in some respects, are the Bush era policies on stilts. They're not only not changed, but in some ways more extreme, and certainly issues that I think you care about most, the state secret exception, torture, and those issues. There's some real question about whether they've been addressed. I wonder if you could set the table for a minute and talk just briefly about, at the beginning of this month, the Obama administration announced that they'd been holding a Somali terrorist in New York. They had questioned him apparently almost daily on a naval vessel for 2 months. Before bringing him to be indicted in a federal court in New York. I wonder if you can use that to talk through these questions of Obama policies versus Bush policy. Is this a hybrid we're seeing? Is this better? Is it worse? Is it bringing us closer toward a universe you want to see or farther away?
I don't want to gloss over the substantial changes that President Obama did undertake in the beginning of his office. I mean, obviously, his making clear again that torture was once again illegal, that which should never have been permitted, was an important step bringing us back into a box of lawfulness. his willingness to close down the secret sites, his willingness to ensure that detainees would be treated humanely, all of which were departures from the Bush policies, were an important reestablishment of the rule of law. And so that deserves the credit due, especially from jurists like us on this panel. The place where I demur, a number of them, I can't help myself, it's that the recent incident of the Somali, where he was held for 60 days on a naval ship before he was given his rights and then brought into law enforcement, is not change. It's too much of the same. It's not that much different than what we heard from some of the critics, including my own organization, where individuals were held in military bases, in military facilities. And yet, it does raise some very significant questions for the Obama administration. They are reaching a crossroads, which they find themselves increasingly compared to the policies of that which of George Bush. They made illegal that which was always illegal, that which still requires a level of debate and discussion about detention and the rights of detainees and where they are apprehended, continue to be muddy waters for the Obama administration. I will say this. The one thing I will take issue with you, Dahlia, because I have to be an equal opportunity critic here, and I'll get to the police commissioner at some point, I hope.
I'm blameless.
That's not what my LA office says. There was never a golden moment where the civilian trials were appreciated by the Bush administration. It was my colleague, Judge Gonzales, on the left, who was the major force and major voice for why we should be able to hold Jose Padilla, let's name a name, an American citizen apprehended in Chicago. And it was this administration, Judge Gonzales' administration, who thought that we could hold him without charges or trial. Civilian trials were not beloved in the early days of Bush 1. It was only after, as David said, we pushed them back into a corner and said, wait a minute, you can't pick up an American on American soil and hold them indefinitely without charges or trial and call them an enemy combatant. That's not what the Fourth or Fifth Amendments allow. And so there wasn't this heyday of love for civilian trials in Bush 1. The second, I would say, is that on the drone issue, to Professor Yu, we have been one of the few voices criticizing the drone program. In fact, I'll send you the case we brought on behalf of Mr. Alaki, an American citizen in Yemen, who the American government has quite quietly but quite vigorously said they are hunting him with drones. His father, a U.S. permanent resident, approached us to represent Mr. Alaki's interests. Drones are highly problematic. And perhaps the most important point I can make here is that the framework of war is wrong. This war is not like the Civil War or the Second World War. This war will never come to a public decisive end. We do not have established lines of the battlefield. This war will end only when we reinsert ourselves in a lawful approach to dealing with crimes. And the fact is, when will we allow ourselves to restore the rule of law when you have an enemy that's dispersed throughout many countries, sovereign nations, where we think we can drop bombs in a sovereign place like Yemen, which, as I understand, there's not been a declaration of war against Yemen, hunting an American citizen to deprive him of life, and yet there is no adjudicating mechanism. There's no way to get that into the courts. We endeavored, we failed. It does raise these very significant issues. And I would argue that, in fact, it's this war paradigm which will never come to a public decisive end that's going to be the most troubling for us. When the Japanese Americans were interned in World War II, we let them out after the emperor threw his hands up in the air. When will we let out the detainees at Guantanamo who are held indefinitely without charges? What will be the deciding moment when those who are held without charges or trial, have not been convicted, will be released? What will be the denouement? And I think, frankly, that is what is most concerned to us. Yes, the rule of law has been resilient, not without a lot of effort, not without a lot of frustrations. And I think, frankly, that the Obama administration, what is most concerning to me is that if President Bush was the architect of a system of impunity and lawlessness. It has been the lack of actions in certain key places by the Obama administration has made President Obama the willing accomplice of George Bush. And I think nowhere is that more important than the failure to prosecute at the highest levels of office for those who made mistakes in drafting memos that enabled American soldiers to break the law.
I'm gonna let John, you respond to that.
Thank you.
Yeah, because he's going to otherwise crawl across the chief.
Oh, no. I never crawl across the chief. I crawl under a chief, but not over a chief.
Go ahead, John.
I'm actually glad Tony put it that way, because I agree with the starkness of the way he pitched the question before everybody, because I think what the ACLU, and I don't doubt their principles and their beliefs, or what David, I think, would also want to return to, is take us back to the world of September 10th, 2001, where the primary method for fighting terrorism was the criminal justice paradigm. You hear it, I think everything he says, right? There shouldn't be any military commissions. There should be no detentions without trial. There should be no gitmo. We should be giving every terrorist a lawyer. We should be giving them a trial in civilian court, preferably downtown New York City for Khalid Sheikh Mohammed. We shouldn't be using drones. We shouldn't be collecting intelligence in any military method. We should be using the system that the domestic police use. I think on September 11th, 2001, the events there showed that system failed. I think that if we kept to those purely law enforcement approach, which many of our allies around the world do. I mean, in Europe, which David referenced, Great Britain, they do think of terrorism as a criminal justice problem. But I think if we had kept to those methods, we would not have achieved the successes that have occurred under both the Bush and the Obama administrations. Take a look at how we were able to kill al-Qaeda's leader this year. Right? How did we get the intelligence for finding bin Laden's couriers and ultimately bin Laden? Right? It was a combination of the interrogation methods, sometimes tough or harsh. You could call it torture. I don't call it torture. You can repeat the word torture all the time. I can repeat coercive interrogation all the time. And we can take a look at the actual methods, and people can decide for themselves whether they constitute torture or not. But I think that those methods produced the names of the couriers, and then it was warrantless surveillance that allowed our intelligence agencies to find the couriers actually where they were, that led us eventually to Abbottabad. I think if we had kept to this pre-9/11, this terrorism equals crime paradigm, we never would have been able to find bin Laden and kill him. I actually preferred we would have captured bin Laden, but that's another question. We also, I don't think, would have been able to find, and using drones, which I take it are now illegal, use drones to remove most of al-Qaeda's leadership over the last 10 years. So ask yourself, where would we be if we had to return to this criminal? I think, I mean, I wasn't clear in my previous statements. I do think that the move to the terrorism as war paradigm is what has led to our victories in the war on terror. And I think it has been worth it. And I think there have been minimal, if any, infringements on civil liberties. So so thanks for giving me the chance. I just want to make one last point about this commander-in-chief issue. I think David and Tony make this claim that when the president acts under as a commander-in-chief authority, he's somehow acting illegally if he's in conflict with a congressional statute on the same point. Now, this is a long question in American history, American constitutional law. It is not a settled question by any means that the president has to obey every statute passed by Congress, even those which infringe on the president's constitutional powers, just as Congress cannot infringe on the powers of the courts either. And so we can argue about where the margins of that are, where you resolve specific disputes, but the idea that the president has to obey every act of Congress is just not true. And think about what would be the case if that were a fact. I guess President Lincoln could not have freed the slaves because the Emancipation Proclamation was an act of the commander-in-chief power inconsistent with the Supreme Court cases of the day and acts of Congress of the day. President Roosevelt could not have brought us to the help of the Allies before World War II. And President Obama could not lift the debt ceiling unilaterally, which I think a lot of liberals would like him to do right now. Although I don't think he has this power domestically. He certainly doesn't have it domestically if he doesn't have it in foreign affairs.
I want to ask Chief Bratton a question, but it's a little bit going to change the subject. So I wonder, David Cole, do you want to respond to the claim that Osama bin Laden was captured based on evidence that was procured through waterboarding and surveillance, or is that something you want to leave alone?
Well, I'll respond. The argument that torture works, which John and others have made, I think there's no actual evidence for it, and there's been a great deal of debate in the wake of the Osama bin Laden killing as to whether, in fact, there's any basis for the claim that enhanced interrogation techniques led to the finding, 8 years later, of Osama bin Laden. And most people say no, including Donald Rumsfeld, who said there was absolutely no connection until he, in his first response, until he heard that people like John and Dick Cheney were saying, yes, there was a connection, and then he said, well, maybe there was a connection. But I think, in fact, if you look at the accounts, very detailed accounts that we don't really have time to go into here, it's a very, very speculative claim at best that this led to the identification of Osama bin Laden. But more importantly, of course, the argument that torture works isn't a justification for torture, right? The reason that the world has made torture, put it off the table, said that it's never permissible under any circumstances, including during wartime, the reason that it is a central provision of the Geneva Conventions is not because it doesn't work. It's not because, it doesn't get us useful information. It's because it's wrong. It's wrong morally, and it's so morally wrong that the world agreed on that, and the United States agreed on that until shortly after 9/11, where for a period of 5 years, in secret, the Justice Department reinterpreted the law to allow what had clearly been illegal before to be permitted. And I believe you, Judge Gonzales, when you say that the lawyers spent a lot of time. But I think when you look at the results of what they spent a lot of time doing, they spent a lot of time not seeking to conform the policy to the law, but seeking to bend the law to allow the president and the CIA to do whatever they wanted. And that, I think, is not the appropriate role of a lawyer in the Justice Department. He's not a hired gun. He's not there to find every loophole. He's not there to wipe away the constraints. He's there to enforce the constraints, because if the lawyers don't enforce the constraints, who is going to enforce the constraints? And I think to me, that's the most disappointing aspect of the post-9/11 period. But as I said, I think the most encouraging aspect of the post-9/11 period is that I think there's a general recognition that was wrong. I mean, if you look at what John Yu's successors said about his memo, Michael Mukasey, that it was slovenly, that is the torture memo. Jack Goldsmith, that it was riddled with errors. The Office of Professional Responsibility of the Justice Department, that his ideology overcame his commitment to providing honest advice. I think that's a broadly shared view now, that this was wrong. I don't think there's been accountability, and I think that's a problem. But I think the rule of law and the recognition that torture should be and is off the table going forward is much stronger today than it was, and that I'm encouraged by.
I think that Judge Gonzales also wanted to respond to that line, and then we really are going to loop in the Chief. Okay.
I just want to make sure that everyone understands that Congress criminalized extreme acts. The statute, and no one's ever been prosecuted under, and that's why the work of the Department of Justice was so critical in the early days of the war on terrorism. I mean, it's the intentional infliction of severe physical or mental pain or suffering. That's the anti-torture statute. Well, what does that mean? Well, we know that when Congress ratified the Convention Against Torture, we had an obligation to criminalize torture. And the statute that arose reflects Congress' intent of what constitutes torture, only those extreme acts. Now, the Convention Against Torture also says that we are not to engage in acts that are cruel, inhumane, and degrading. Well, what does that mean? Cruel, inhumane, and degrading. We know it's not the same as extreme acts of torture, and we also know that Congress did not criminalize cruel, inhumane, and degrading. I think a lot of people look at some of these techniques and say, gosh, that's extreme, or gosh, that's cruel, or gosh, that's inhumane, gosh, that's degrading. It may be, but it wouldn't satisfy the requirements of torture. And Congress, because they were concerned about the vagueness of the term cruel and inhumane and degrading, they took a reservation saying that it would only constitute cruel, inhumane, and degrading if it violated our Constitution. And that standard is, does it shock the conscience given the circumstances? And so, as lawyers, our job is to interpret the statute. We're talking about a criminal statute, criminal conduct. We want to be very, very precise about what conduct violates the statute against torture. It may be unpleasant, it may be cruel, it may be inhumane, it may be degrading. But if it's not torture,
well, that's why
you don't meet the statutory definition.
That analysis fails to account for the fact that the American government prosecuted Japanese soldiers for waterboarding American soldiers. I talked to one of them, an American soldier who was in a nursing home in West Virginia, when we prosecuted Japanese soldiers for waterboarding them. So let's just read the language. You said let the American people, let's read your language. The waterboard, which inflicts no pain or actual harm whatsoever, does not, in our view, inflict severe pain or suffering. Even if one were to parse the statute more finely to attempt to treat suffering as a distinct concept, the waterboard could not be said to inflict severe suffering. The waterboard is simply a controlled acute episode lacking the connotation of a protracted period of time generally given to suffering. Now, that's the best analysis that our lawyers could come up with.
I'd like John to respond to it.
And it's just, no wonder you have to spend a lot of time on this.
With the dramatic accents, and the Dickensian, I don't know what to call your very good actor's interpretation of the memo. But you want to get into how we looked at this. So the judge is right. I mean, this is a statute that was uninterpreted, unenforced at the time that 9/11 arose. We've had a lot more years now. Congress has gotten involved to pass follow-on statutes. But put yourselves back at the time, because people yesterday were talking about hindsight bias, and lawyers are very guilty of hindsight bias. Saying, the answer is obviously clear. How did you not know? We now that we have plenty of time, we could figure out the best answer. That's not the case we were in the days after 9/11. So what did we do? Well, we went back and looked at all of the American soldiers who've gone through SEER training. I'm sure actually there are members of the audience here who've gone through that, which is where I take it the CIA actually developed these interrogation methods. And we went back and said, what are the medical results of all of the people who've gone through SEER training? And the Department of Defense reported back that I think the percentage of soldiers who'd had any kind of negative reaction psychologically, because there were no reports of physical negative reactions, was something like under 1%. And so look, I think it's easy now, 10 years after 9/11, and after you've gotten the benefits of the intelligence to achieve the victories against al-Qaeda, to say you went too far. But if you put yourselves back in that situation, you have to interpret an unclear law. You've got people, the thing that struck me yesterday afternoon listening to Gary Benson on his panel was how unclear the law was for the operators we're sending into Afghanistan to actually carry out these actions. The last thing you want to do is to send them out there and say, the statute says don't inflict any pain or suffering. Good luck, you're on your own. I think it's the obligation of people who sit in comfortable offices in Washington, D.C., when they send men and women out there into the field to carry out these fights, to be as precise as possible, and to stand up and protect them afterwards when they come back against people who I just love hearing defense lawyers calling for people's prosecution. I love it, because usually these guys are in the business of defending people from prosecution. Today, they're yelling and screaming that everybody has to be prosecuted. There have been independent counsels who've looked at this. There have been not independent prosecutors, but there have been prosecutors in the Eastern District of Virginia who've looked at these cases, who are career civil servants, and they've made their decisions about whether to bring prosecutions or not, and I'm happy to live with what they decide. They've decided not to bring prosecutions against most of the agents involved. If they want to bring any of us as defendants, fine, let them. I totally agree with accountability. But this claim that there's this kind of lawlessness and everything was run haywire and we're just letting people do what they want and the CIA did what they want and then came back later for legal approval is just not consistent with the facts, and sort of imparts this kind of godlike intelligence and knowledge that ought to be on the part of government officials as impossible. You have to act under very pressured circumstances of time and resources. in an area where I'm afraid, unlike a lot of things the government does decide, if you just wait and do nothing, you're going to cost American lives and American security.
I'm sorry. I knew that this would happen, that torture would take over the panel, but I do want to ask the chief a question, and I know that the clock is ticking quickly toward the Q&A. Oh, very quickly toward the Q&A portion. So Chief Bratton, do you want to comment on anything you've heard, or shall I ask you? Shall I just change the subject?
As your lawyer, I advise you to remain silent.
You have the right to remain silent. Anything you say.
Let me put it in the form of a question. How about that? I remember Darius Rejali writing, and forgive me if I got his name wrong, right after Abu Ghraib, that some of these Freudian slip. Some of these interrogation techniques were going to migrate from Abu Ghraib to the United States domestic police forces. Have you seen evidence of that? And I wonder if also you might talk briefly about racial profiling post 9/11 and any experience you've had thinking about that.
Okay. First, in terms of concerns about a migration from the events over there back to the United States, I don't think in law enforcement we had that concern. I commented earlier that we're fortunate at this time in our history that particularly over the last 40, 50 years, the control over American policing has been extensive. The embrace of it by American police leadership has been very extensive in the sense that I've been a policeman for most of my life. I work with cops. I like cops. I think I understand them. They can go out of control faster than any human being because of the pressures and tensions and conflicts they're constantly facing. So you need to have very strong controls over them. The Miranda rulings, the exclusionary rulings, these are all things that benefit American policing and by extension the American people because they control the police. And I have now on several occasions filed amicus briefs in support of, along with my colleagues in policing, when there have been efforts to undermine or reduce the impact of Miranda, for example. We live with it. Are there those that would abuse it? Certainly. In Chicago in the 1980s, you had a detective who tortured and sent to jail over 100 African Americans. That individual finally has been brought to justice. But what he inflicted on those individuals is the exception. In the state of Illinois also, by extension, in the 90s, the governor's actions there, maybe it was more recent than that, in which it had been clearly determined that 6 people on death row were in fact sent there inappropriately because of torture, coerced confessions. Fortunately, I think that the issues are being discussed here about dealing with terrorism, dealing with the issues of war, that have not filtered back into American policing. I think there's been a maturation, and all of us benefit from that. And the idea that that we are a nation of laws, that there is the rule of law, it is undecided, as this panel has clearly shown, as it relates to the war on terrorism or issues of terrorism. But I think it has been clearly decided in the day-to-day lives of Americans in the sense of how our police act, how they are controlled. Torture is not condoned, is not authorized under any circumstance, and police uses of force are the most closely looked at uses of police power and abuses of police power in our government. As to issues of racial profiling, which have become, we tend to associate mostly with African American issues because of our history, but more recently now because of the war on terrorism, the issue of Muslims, Islam, that has surfaced again. Once again, I think American policing showing a maturation of that profession that I'm so proud to have been part of, that we are at the forefront of tackling racial profiling, trying to prevent it from occurring, not without mistakes, not without exception, but that the lessons learned from our abuses of African Americans back in the days of segregation, that helping to inform us in this issue. And American police chiefs, by and large, have been very much on the front line in terms of ensuring that a lot of our activities are intended to protect Muslim citizens from potential racial profiling as a result of all that's going on as we fight the war on terrorism.
Thank you so much. I'm going to open this up to questions because I knew there would be many, many of them. I'm going to just urge you to state your question in the form of a question and to really do it as briefly as possible. There are microphone people, I'm told, running around. So how about you right over here? Yeah. I'm sorry, I don't know. Okay.
Hi, Tommy Sowers with the Iraq and Afghanistan Veterans of America. I did graduate high-risk SEER in 2004. The period of time where you're interrogated is about 70 hours. It's probably a difficult analogy to compare to 70 weeks or 70 years. But it's a question for the broad group. We just heard that the president can not adhere to a law that he believes is unconstitutional. As a military officer, we have the exact same thing. We swear to support and defend the Constitution of the United States. The president is preserve, protect, and defend. So, Professor, you've been critical of JAG officers that have created their own interpretation of the Constitution. So my question is, when a military officer thinks that an order is wrong, we're told not to follow it. When a military officer believes something they're told to do is unconstitutional, should they follow their own interpretation or the interpretation of an unelected political appointee?
I mean, that's a great question. It's a hard question. I would say, right, as an officer, you take an oath, actually a similar oath to those of us who serve in the executive branch or every branch of government to uphold the Constitution. And so I would say no officer of any branch of the government should carry out a decision that they believe to violate the Constitution. Now, I'm not saying that all of our soldiers in the field in Afghanistan and Iraq should have their pocket constitutions in their backpack and consult it every time they get an order to do something. I think you'd have a real breakdown of discipline within the military. So I think that, and I would not, God help us if all of you went to law school, we'd be real trouble. Right? So I don't want you all sitting there, studying constitutional doctrine all the time.
You could just call us at the ACLU.
Yeah.
And we'll give you our analysis.
God would really have to help us then after that happened. That would be a really interesting war, though, because you would hand the guns over to the other guy, and then you would. Well, I'm sorry. So anyway, like I said, the Puerto Rican-Korean thing, where countries are not close enough to get into a real war, but this is... Anyway, so...
Not yet.
Not yet.
Bringing it home.
Yeah, okay, I'm sorry.
Where are we going?
It was such a great... So I do agree with you. If you're an officer and you think you've received an unconstitutional order, you have taken a personal oath, right, to defend the Constitution, not to defend people whose orders may be in violation. But that doesn't mean, though, that doesn't mean that, say, the Army or Army JAGs can have their own interpretation of the Constitution that is more correct than, say, the President or the Supreme Courts. I mean, that's for actually every citizen to decide. But I think I think officers and soldiers have to defer to somebody because you're not experts. You're not going to law school. You're not studying Supreme Court opinions. Like I said, that's really for the best of everybody that you not do that. And so I don't fault people who go to the JAGs in their units and would ask them. But I don't think that you should ever be in a position of saying, because I'm an officer, I have to follow an unconstitutional order.
Okay, next question right here.
Richard Benveniste, former 9/11 commissioner. Two things. One, the 20th hijacker, Mohammed al-Qahtani, was turned back from Orlando International Airport by an astute immigration officer who did not allow his entry into the United States. He was later captured on the battlefield in Afghanistan. He was interrogated. His identity was at first unknown, then the connection was made. He was providing information. Then orders were received, we understand, from Washington, perhaps from the Vice President's office, to subject him to enhanced interrogation. We are told that did not include waterboarding, but we also are now told that the infliction of these enhanced interrogation techniques have left him essentially a vegetable, unable to stand trial. I would have liked to have seen him brought to the United States and prosecuted as the 20th hijacker in that plot. So this is the first question about why that was done. Secondly, I'd like to mention one of the 9/11 Commission's recommendations was to create a robust civil liberties and privacy board. The Bush administration created such a board, although it was watered down and lacked subpoena power and other things that we had recommended. The Obama administration, surprisingly to many of us, has not created such a board. It has nominated 2 members. It does not appear that such a board will become a functioning entity. I believe that such a board would mediate a public, mature discussion about where we are in the area of civil liberties, whether data mining, pattern recognition technologies that are available should be used, what the constraints are, and how we will better protect ourselves. And I'll close with just a note for those who may be thinking about the last session in which there was some discussion about whether President Clinton provided authorities to the CIA to kill or capture bin Laden. That discussion appears on pages 133 and 134 of the Commission's report. It also appears in the sworn testimony of former CIA Director George Tenet in March of 2004, where he swore that he had such authorities.
I wonder if someone wants to speak to Al-Qahtani, the initial question. Professor Cole?
Yeah, Susan Crawford, who was President Bush's chief prosecutor at Guantanamo, dismissed the case against Al-Qahtani because she concluded that he had been tortured, and therefore he could not be brought to justice. So there's a clear example of the kind of cost that this technique has laid. I also agree with Richard's suggestion about the privacy board, and I think it's consistent with the kind of concerns about accountability that Judge Gonzales raised, that Anthony raised in a slightly different way. Accountability doesn't have to be in the form of a prosecution. That's sort of law and order type accountability. But accountability comes in many forms. And if you have a public airing and you have an official body which is responsible for making certain judgments, that can be a form of accountability. So, for example, in the United Kingdom, when they were fighting IRA terrorism, they initially responded much as we did initially, by detaining people without charges, very broadly, many of whom were not justifiably detained, by then using coercive, torturous interrogation tactics against them. It had blowback effects, but when it was disclosed, they didn't say, well, we're just going to look forward, we're not going to look back. They appointed, the administration appointed a commission headed up by a former law lord, and they wrote a report and found that these tactics were not only wrong morally, but illegal. And that is part of the culture in the UK, where torture is off the table as an appropriate matter of discussion. Torture is not off the table in the United States yet as an appropriate matter of discussion. When you look at polls, they, about 50-50, depending on how you ask the question, people think torture is sometimes justified. That's not the case. I think part of the reason that we are still in that place is because there is no such board. There has been no commission, as there was with 9/11, to look into these mistakes that I think may not warrant prosecution. I've never called for John's prosecution or Judge Gonzales's prosecution.
Now I'm really disappointed.
I'm too much of a defense lawyer, but I have called. I do think the right thing to do is to have some form of official accountability. You can't just look forward, not look back. That's not how you learn from history. Other countries have learned, have shown us how to do it. I think we're strong enough to do it.
I think Judge Gonzales wants to address
I just
that.
want to be very, very clear. I mean, President Bush was clear in saying we do not engage in torture. Now, even under a ticking time bomb situation, I know Chuck Schumer in the Senate Judiciary Committee hearing with Ashcroft said, of course, you do whatever you have to. If you've got someone who knows about a bomb that's about to go off in New York City that could save millions of lives, yes, you do whatever you have to engage in torture. President Bush did not believe in that. He said, you tell me where the box is. We're not going to go beyond the box no matter what the circumstances are. We don't engage in torture. We don't believe in torture, no matter how effective it is. On the 20th hijacker, I don't remember a situation where Vice President Cheney ever ordered enhanced interrogation techniques. Maybe he did in this case. I'm just not aware of it. I do know that the purpose of these techniques was to gather information. That was a primary purpose. And quite frankly, President Bush was more interested, in my judgment, in prevention than in prosecution. Now, obviously, you want to bring people to justice if you can, but the main concern for him was the protection of American citizens, and that's why these enhanced interrogations were important for him.
We've got time for one more question, for which I am so very sorry. Right over here.
Hi there, Dan Prieto, former project director for the Council on Foreign Relations Task Force on Civil Liberties and National Security. So over the last number of years, I feel like we've been presented a false choice every time we have a session like this, that it's either the laws of war or criminal laws. And I would ask the panelists, these are both valid tools. Yeah. Clinton approved armed conflict to go after terrorists, laws of armed conflict, authorization for the use of military force, Supreme Court has backed it up. Why can't we agree that we can use both sets of tools and not fight the war on terror with one hand tied behind our back? I think that is a way to move forward. And for example, with the KSM trial, I would have liked to have seen him tried in a criminal court in Manhattan. It would have been a victory for our values to have him near ground zero, getting tried, getting convicted. But to be honest, I don't think the American people care. If he gets convicted in a military tribunal, I'm just as happy.
Does anyone want to?
This is where Anthony and I disagree. I actually think that it is appropriate to use war methods in response to the attack of 9/11 and in response to a country that was harboring those who attacked us. I think that was an appropriate response. I think it was an effective response, and at least initially. And I also think that the criminal justice system is an appropriate and effective response to terrorism. We have the Bush administration and the Obama administration prosecuted many people successfully for terrorism. We continue to do it. I don't think there's anything wrong with using both. When we do drug law enforcement, we do state drug law enforcement and we do federal law enforcement. There's a lot of overlap. It gives the government choices. There's nothing inherently wrong with that. What I think is critical is that within the framework, first of all, deciding which framework applies in a particular context is critical, and there's a lot of debate about that, but then within the framework, abiding by the rules that govern that framework. So, for example, I don't think Guantanamo would be the black mark it is around the world today if we had done three basic things when we put people there. We said we are only going to lock up people who are in fact enemy combatants, and we're going to have hearings where there's a doubt to ensure that we're not locking up the wrong people. President Bush said no hearings, we know best. 2, we're going to treat them humanely because that's what the Geneva Conventions require, and that's what we have always done as the United States Army. President Bush said no, treat them humanely except where it's necessary not to treat them humanely, and then you get cases like Al-Qatani. And 3, we detain them only for the duration of the conflict, the authorized armed conflict with Afghanistan and with the Taliban and Al-Qaeda, as is justified by the law of war. Instead, we had a president who said, we can hold anybody we want, no hearings, we can treat them inhumanely, and we hold them for as long as the war on global terror goes on, which will never end. So I think if you abide by the rules within the right framework, then I don't think Guantanamo would be a problem. Every nation that's fighting a country holds people who are fighting against it for the duration of that conflict. We're still in a conflict. So there's nothing wrong with doing that, but you got to do it in a way that's consistent with the rules that govern that framework, and we didn't.
I'm being told that I absolutely may not take another question. It's a comment on how important these issues are, that people have so very many questions. I urge you to come speak to the panel, and I thank you very, very much for making this conversation possible.